I was fascinated by this topic, talking justice. I wasn't sure whether it was an oxymoron or a tautology, but maybe there is no inherent contradiction. I had hoped that Mick Dodson would have been here because my remarks are very largely addressed to the constitutional suggestion of which he is part, is that with a reconciliation with our initial citizens, or our initial occupants anyway, of the country, we should perhaps move outside the confines of the Constitution and set up a national statement about reconciliation, which can then have such legislative input as may be given by each of the colonial governments, otherwise known as states, and rather than attempting to amend the Constitution by way of referendum. Sounds a bit complicated, but as I will go on to say, these things can be married. I must say, it's refreshing to find that the early releasees, of course, are sitting in the back of the auditorium here, but I can see down the front that the parole board's been very busy of late. It's a wonderful juxtaposition to be in this prison, which I helped to equip with customers and in the past. And as you came through the main entrance, you would have passed underneath the trapdoor of the gallows, in which 3 of your fellow citizens were dispatched into the netherworld and buried, standing upright, it might be said, against the prison wall. Such was the appalling way in which even dead criminals and felons were treated in the past. Now, of course, they're lionised and will be probably featuring in the next AO list at the new year. Now, what has Bendigo got to do with justice, with the Australian Constitution? I take it that most of you people come from Castlemaine or other trendy cities close to Melbourne. Are there any workers or working people from Bendigo? Could I just get Oh, yes, we have some native Bendigonians. Well, they, of course, will know all this, and the comprehension test follows my little talk here, and failure to comply is 50 lashes. Bendigo is in fact attached to the Australian Constitution and the Australian system of justice. Back in 1853, just after the worst of the gold rush was over and settling down, the system of licensing required the miners and the diggers to pay their licence fee in advance, whether they had found gold or not. This, of course, was a great burden. Now, the diggers who came here were not your working class poor. To come to Australia, you had to pay in advance, and remember, it was a 4-month journey. So that it was the men driven, and they were men driven by initiative and who had a few bob and some education. The poor and the dispossessed went to the United States of America, from which it has never recovered. So it was 4 days across the Atlantic, but 4 months to get here. So our miners were vaguely literate and certainly a little bit more socially aware, particularly in Bendigo, because they were Cornish and of the chapel. So that in 1853, the protesting against the unfair licensing system led to the Red Ribbon movement, a complete lift of the red cockade from the French Revolution. And the miners protested at this system of licensing by wearing a red ribbon and conducting a monster rally. A monster rally it was, where it seems that about half of them turned up at the protest meetings. This ultimately led to Eureka and the Stockade event in Ballarat, which is a suburb of Bendigo to the southwest, some 18 months later. I'm happy to tell you that the Red Ribbon movement was led by a lawyer, George Thompson, and it was he and another man called Dexter who devised their banner, which you see embedded in the Australian Natives Association banner, of the crossed shovels and pick, the sailing ship, and other symbols which we might pick up and give more esteem to than the Southern Cross that surfaced in Ballarat. The following year, and I'll come back to the significance of the Red Ribbon movement, was the formation in Bendigo of the 8-hour movement, originally begun by the stonemasons in England, but very much pushed forward by a local mine owner here in Bendigo called Maurice Coleman, aka Kalisch. He was a German Prussian and changed the name to Coleman. He was assisted by another local solicitor, a fellow called Robert Clark, and at the time they were assisted by another lawyer who was mentioned here as one of the sponsors, Hyatt, and I think somewhere on the list of sponsors. Anyhow, it's a firm existing in Bendigo which is still here. And that prospered the 8-hour movement. How does this become relevant to our Constitution? The work of the 8-hour movement ultimately surfaced in the Australian Constitution as the conciliation and arbitration power which was assigned to the Commonwealth from the colonies pursuant to the pen of John Quick. John Quick, again a local lawyer here, had been in the colonial government in Victoria and became the local federal member, pardon me, in 1900. Sir John Quick, as he became, wrote, together with another lawyer, the foundation work of the Australian Constitution. He had been a Cornish miner. He went into the mines at the age of 10. He was exposed to the exploitation of children and to the long working hours, and he took the issue of 8-hour day and industrial relations to his heart, and it surfaced again, as I've just said, in our Constitution as the conciliation and arbitration power. He'd been a journalist on the local paper, plodding prose, and my God, he was plodding to listen to, and nevertheless made a huge contribution to the Australian Constitution. So Sir John Quick, a foundational figure in matters of law and legal process in this country, followed by the dreaded W.M. Hughes at the time of the conscription riots, wish they had been, the conscription referenda. Hughes, as you know, put up the first referendum to fill out the ranks of the Australian Army so that they could be slaughtered by British generals. Just a little bit of hyperbole added to keep you on your feet. In 1916, that referendum lost. He was in Newcastle at the time, realised he wouldn't get re-elected, and came, or was enticed to come to Bendigo, where he was elected as the local federal member. So here in Bendigo, right here, the huge constitutional issue of conscription, remember, it would seem to transgress every moral principle, coercing men, and they were largely men, to give up their lives. Could it really have been said for their homeland? Perhaps yes, perhaps no. But a very significant moral issue which resurfaced, of course, in Vietnam. Well, here in Bendigo, the first conscription speech that Billy Hughes gave was at the Lyric Theatre, since demolished, but about 3,000 turned up. And his speech divided this community as the Australian community was divided. Conscription was largely endorsed by the Protestant ascendancy and the local Protestant ministers. Some of the local Catholic ministers also did support conscription, but on the whole, they were against it. And I'm glad to tell you that the conscription referendum failed here in Bendigo as it did nationally. But the divisions in that fight remained until we now have the ultimate triumph of the DLP in the form of the Liberal government. And just another piece of hyperbole to keep you on the edge of your seats. I can see I've got some historians here who are now, having an attack of the vapours and the salts and so on. But that dreadful sectarian divisions, which fortunately are abating at an enormous rate, were born out of that dreadful referendum, and it was there that it was here rather in Bendigo that it had its source. Just going on a little bit further about Billy Hughes. He remained the local member here to 1920, where he changed parties, I think, for the third or fourth time. And he was asked the immortal lines, "Why haven't you joined the Country Party?" And he said, "Oh, you've got to draw a line somewhere." Further involvement in Bendigo in the Constitution, I suppose. I'm going to indicate some personal history here. I was working as a cabinet advisor to the Whitlam government at the time of the dismissal, and out we went. I was in the room when the Governor-General actually phoned Diamond Jim McClelland at the time of that crisis, and you will be the first to have it revealed to you that that was highly improper for the Viceroy to contact anybody but the Prime Minister. Our Constitution functions on convention as much as it does on the written word, and it was highly improper for Kerr to have thought that he could have a word with Diamond Jim, which was then supposed to find its way back to Whitlam, Kerr not realising that nobody but God spoke to Whitlam at the time, and even she spoke in muted terms. So I went through the matter of the dismissal, and I resurfaced in another incarnation as counsel assisting the chairman at the Constitutional Convention in 1997 about a republic. All of this leads me to the view that constitutional referenda are very hazardous projects because it brings out the rednecks, the nuts and berries, as much as it does the good citizen. And there is much to be said that as we move towards reconciliation with the Dja Dja Wurrung and other clan groups here, the Tuggeranarong, we must consider very closely whether we do it constitutionally by way of referenda or by way of some freestanding objective standing outside the Constitution. The justice is compelling. The need for justice is compelling. What is it? Leave that to David. But I'll give you an example of how far we must travel. Out on my farm, I was working pretty hard with one of the local fellas. He had, one tooth and a bit of hair and so on, and the arse out of his trousers. And he said to me, "I thought you were a Catholic." And I said, no, I'm a Jew. He said, "Oh, that's even worse." So there is some distance to travel dealing with the inherent problems in our community, but this is a good start. Thank you.